Hello, everyone. Good morning. My name is Nachtschatt, and my topic today is the legal capacity. First, thank you to the organizer and thank you for this great opportunity to be here and to have this talk. So, okay, let's jump right into the topic. Which is to answer the question, what is legal capacity, which is a huge challenge. Yeah, let's start. Not the term, but the concept of legal capacity was already known in Roman law. As is well known, civil law is based on Roman law, and therefore the concept of legal capacity contains a rather old understanding of capacity combined with very old and outdated image of women and people with disability, for instance. Only the UNCRPD brought a significant change and provided a fundamental impetus to look in depth at the concept and the understanding of legal capacity. In this presentation, I will, as a main step, look at the term legal capacity itself and then highlight the different concepts which are contained in the term. In the context of this conference, the concept of legal capacity is to be seen in the frame of the UNCRPD with all its fundamental rights. In addition, as an example of legal capacity, I will go through the Austrian legal capacity with you. I think in the context of the UNCRPD, it makes sense to break down the general concept to national as well as to individual levels, which we are going to do. In order to shed more light on the term, the text of the convention and the general comment number 1 should be consulted. The entire drafting and development of the UNCRPD has been a remarkable process. Having the text after its adoption is good and important, but the implementation at the national level is decisive for the individual concerned. The English term legal capacity chosen in the convention summarizes the legal personality and legal capacity to act. On the one hand, the term refers to the ability to be the bearer of rights and obligations. On the other hand, to act legally on this basis. Utilization according to the model of the Article 16 of the Civil Code from 1966 applies to every human being and encompasses all areas of life. Legal capacity is understood as a concept of legal capacity and legal action. I will go into more detail on the next slide. The first general comment was adopted in 2014 and dealt with equality before the law. The early attention given to Article 12 and thus to legal capacity is a signal how essential this particular is in the area of the CRPD. During the negotiations around the convention text, there was a lot of debate about the importance and the meaning of the term legal capacity. There was disagreement over whether legal capacity should be understood as the ability to perform legal acts or the ability to be subject in law or both. Because of this background and of the different languages in connection with the different legal systems, the negotiators agreed to avoid misunderstandings that the recognition of legal subjectivity and equal performance of legal capacity should be accommodated in 2 separate paragraphs. So Article 12, para 1 and para 2 Recognition of legal capacity is regarded as a fundamental requirement for exercising civil, political, economic, social, and cultural rights. Legal capacity thus plays an important role in all areas of life. The individual interpretation of legal capacity is to be thought at the national levels of the individual member states. We will go through the legal capacity with an example, the Austrian terms, to explain why the question in the title of my presentation is not so easy to answer. Another aspect that should not be underestimated is found in the different legal systems. These should always be considered individually with the respective national and cultural backgrounds. As far as can be seen, no universally valid definition of legal capacity that transcends national borders is known. An internationally recognized definition of legal capacity has not yet been formulated. The Commissioner of Human Rights of the European Union uses the English term legal capacity and describes it as a power and an opportunity to act within the legal system. The concepts of legal capacity and legal action are closely linked and often referred to each other and mentioned in the same breath. The concepts of legal capacity and, strictly speaking, legal capacity to act are conceptually separable. Regarding the CRPD 2006, in particular Article 12, equal recognition of legal capacity and legal personality and legal capacity in the first place is thought of. Para 2 deals with the recognition and performance of legal capacity of persons with disability based on fundamental rights on the same basis as persons without disabilities in all aspects of life. Para 2 is also understood as a principle and specifies the recognition of legal personality of Para 1. Para 2 could also be understood as a hint for the national implementations. The term legal capacity includes the ability to be a bearer or holder of rights, as well as the capacity to be a legal person within a legal system. The legal capacity to be a holder of rights grants a person the rights to use comprehensive legal protection within a legal system. The legal capacity to be a legal person equips the person with the authority to enter into legal transactions or to establish, modify, or terminate legal relationships. The legal capacity unites the legal right to be the bearer of rights and obligation, and to possess the legal power to act, so that to argue rights or to fulfill obligations. Article 12 comprises the legal presumption that people with disabilities have equal rights and legal capacity. The legal capacity is conceptually separate from the legal agency. Legal agency describes the ability to act within a legal system. My research deals only with legal capacity to act of a natural person. The issue of legal capacity to act affects all areas of life of a person, because without the appropriate legal capacity and their recognition of a person cannot make legally valid decisions. The person cannot choose his/her own place of residence, conclude legal transactions, sign employment contracts, decide freely whether he or she wishes to marry. The person cannot exercise her active or passive right to vote and manage her own assets, nor legally consent or refuse medical treatment. The European Union Agency for Fundamental Rights highlights an essential aspect in the definition of legal capacity in general and legal capacity to act. Thus, the concepts are defined by the recognition of a legal person's decision. Only through the recognition of the decision made, the person becomes a legal subject or holder of a certain legal right and corresponding obligations. Without recognition, this decision could not be legally effective and have no validity. Without recognition, the person cannot make a binding decision. The jurisprudence of civil law, in the sense of the civil code, legal personality is described as the abstract ability of a particular subject to be an object of a legal obligation. In common law, all human beings have legal personality because of their natural status. Having legal personality says nothing about rights and obligations of a person. The English term legal capacity refers to legal relations in a narrow sense. Legal capacity describes the ability of a person to take legal actions, assert rights, or fulfill obligations. The scope of a legal capacity is based on the nature of the legal personality and on the specific matter in each individual case. The scope is governed and influenced by civil law, statute law, or both, depending on the area concerned. Legal capacity of a natural person varies according to the respective legal context or circumstances. Constitutional and legal regulations secure certain rights and legal defense to all persons and thus extend the meaning of legal capacity. In other areas of law, certain categories of persons transfer specific rights to varying degrees. That may be the right to marry, the consumption of alcohol, to vote, or to join in the army. These rights refer to different age groups. The age forms the relevant status. The rights depend on the individual ability of a person to understand and react to specific situations. Separate regulations have been created for mental health patients. Different concepts of legal and mental capacity. The concept of legal capacity should be distinguished from the concept of mental capacity. The mental capacity refers to the natural ability of a person to make a decision. This natural ability can be different for each person. How the natural ability is shaped depends on environmental and social factors. The Convention first emphasizes the distinction and separation of the two concepts. Among other things, it is clearly stated that the presence of a disability must not automatically lead to the limitation or withdrawal of legal capacity of a person. This thought refers back to the medical model as deficit approach, in which disability is seen as a personal defect or default, what the Convention is clearly against. So far, the national concepts of legal capacity can be understood as a social legal construction that in some cases suggests that people with disability lack legal capacity because of disability due to a medical diagnosis. This assumption applies a certain value attached to this group of persons. The concept of legal capacity is also considered to be an innate right which belongs equally to all people, especially people with disabilities. The concept of legal capacity includes legal standing and legal agency. The two elements, the ownership of rights and the legal capacity to act, are inextricably linked with each other and are due to each person and due to their equality as human beings. The ownership of rights as first element also refers to the recognition of a person as a legal person before the law. The second element, the legal capacity to act, includes legal action based on the rights referred by law and the recognition of legal acts by the law. In the past, legal recognition is still often reduced or even denied by a legal system, especially to persons with disabilities. The concepts of legal capacity and mental capacity are often mixed up in legal systems. These are legal systems that base their laws on the medical model of disability. Mingling can lead to the assumption that a person's mental or psychological disability, the natural decision-making ability, is impaired, and consequently, the legal capacity to make concrete decisions is denied. The review of the legal decision-making capacity takes place consistently. That is usually without investigation of the individual case. The concept of mental capacity comprises the following elements. The general comment, number one, and linked to this, the Austrian legislator mentioned the ability to make decisions includes three essential elements: the cognitive, the voluntative, and the ability to act appropriately. On this slide, you will find a short summary of what has been said so far, as well as the indication that different assessment regimes are used to assess the legal capacity and the mental capacity. On this slide, I have brought you a number of terms that are used in connection with legal capacity. If one takes a closer look at the terms, one notices that legal and natural abilities can be found. In the context of the term legal capacity, the general use of language and especially the meanings and differences between the terms capacity, ability, and capability should be clarified. In the course of my research, I became more and more convinced that the Austrian term Fähigkeit should be questioned very critically. I will not go into this topic today. The term capacity per se, in the meaning of ability, describes a natural ability of a person to be able to do something out of his or her own physical or psychic power. However, capacity also means the faculty or ability to enter into a legally binding agreement. It forms an essential element of a contract. A person of full age and capacity describes a person who has reached the age of 18 and is sound of mind. If these conditions exist, a person is entitled to enter into a legally binding contract, for instance. The term legal capacity describes the room for maneuver of a person within the framework of a legal system. It embodies a construct without a real objective reality, but forms the connection between legal subjects and the legal system. Legal capacity confers the right to exercise civil rights and to be part of the legal system, and gives a person the legal independence to act for him or herself. The area of capacity, legal capacity, is closely related to decision-making and links the disciplines of law and medicine. Understanding this connection requires interdisciplinarity. The linking of decision-making in the medical field, for instance, requires the involvement of medical experts. The legal capacity forms a fundamental legal constructed barrier for an individual to take specific legal action with the appropriate legal consequence in order to participate in legal relations. For a number of legal transactions, certain barriers, e.g. due age, are provided. However, the barriers merely serve as guidelines as to when a person can be regarded as legally capable of acting independently and legally. The limit determines when a person can make legally effective decisions and thus has legal capacity to act. The Austrian picture or structure looks like this. We have some kind of hierarchy. First, die rechtliche Handlungsfähigkeit as an umbrella term. On the second level, we find Geschäftsfähigkeit, which is somehow comparable to legal capacity to enter into a contract. Legal science and jurisdiction elaborated commercial activities which refer to specific stages of age. In Austria, the structure of the capacity to contract depends on 3 age limits. Among other things, these serve to the security of the legal transaction system. More interesting in this context is the capacity to give consent, for instance, to medical treatment. Capacity to consent supersedes the capacity to understand and the capacity to assess. In Austria, the terms capacity to understand and capacity to assess were used predominantly as main terminology in the fields of giving consent to medical treatment. The second adult protection law brought a new concept of decision-making. In Germany, terms of capacity to understand and capacity to control, as well as the capacity to consent, are used. The capacity to control is used in different ways in Austria and Germany. Let's switch to the next slide. Okay, first, the legal definition of capacity to contract is regarded as the ability to justify and commit oneself through own legal actions. The capacity to contract serves primarily to conduct property legal transactions. There are private declarations aimed at achieving legal success. In the Austrian legal landscape, the term legal decision-making capacity has its way found into the legal civil code, which is exceptionally good. We got a new legal definition of a natural capacity or ability. Capacity to give consent to medical treatment. In Austria, so far the terms As mentioned, capacity to understand and capacity to assess were used. The capacity to understand describes the ability to understand the reason for and the importance of a medical treatment. It embodies the cognitive element. The ability to understand forms the prerequisite for the formulation of will. The ability to assess describes the ability to shape one's own will according to the level of knowledge of current knowledge. It forms the voluntative element. The capacity to assess follows the capacity to understand in time. Psychology knows the concept of decision-making. It describes a natural ability to make a concrete decision and is the result of a complex process. A decision is a more or less considered deliberate and goal-oriented action. A decision should be made in situations in which a person can choose between two or more possibilities, objects or actions, preferences and inclinations, expediences, considerations in relation to one's own current life situation shall be incorporated. Each decision-making process can be different. The degree of difficulty of a decision is measured by the cognitive effort required of a person. Influence on the level of difficulty also has the circumstances whether the decision relevant information already exists or whether it first has to be determined and arranged. So decision is a process of comparative assessment. In the current legal status after the legal reform of 2017, a person who can understand the meaning and the consequences of one's own actions in the respective context determine the will and be able to behave accordingly will be regarded as capable of decision-making. The decision-making ability is assumed in person of legal age. The term of decision-making capacity is new in the Austrian legal order as a legal definition. The new legal definition is intended to be described as the natural ability of a person which should be at least necessary for a legally relevant action. The individual's power of insight and assessment are always to be judged on the basis of the examination of personal abilities. Consequently, the individual's ability to understand and to assess, which is present in a specific situation, for example, a medical procedure, is important. The acting person should understand that he or she has the possibility to take or neglect a legally relevant act, or in a sense, to comprehend the legal effect of the behavior. The ability to make decisions must not be denied if a person does not comprehensively recognize all the consequences of his or her actions. Reasons for this may be inexperience or a lesser degree of knowledge. So far, only the effect of a mental illness or comparable impairment come into consideration. A much stricter standard seems to be applied in the context of assessing the ability of persons with disabilities. The standardization in the form of a legal definition and its positioning of the concepts shows the importance and its comprehensive general character in the Austrian legal civil code. The purpose of the definition is not clarify which actual human abilities for legal actions are at least required. The legal definition is given a binding character by the legislator. Yet the question of the direct connection or the realization between the definition and the practice remains open. In Austria, the capacity is also described as the ability to make decisions. The term capacity is connoted to the term competence, but it should be not ignored that it takes place in a legal as well as a medical context. The legally recognized rules that define capacity and competence vary. Their working definition of the cognitive elements of capacity is composed of a combination of the following components. To understand a specific situation, relevant facts or basic information about the choice. Second, to evaluate reasonable implications or consequences of making choices. Third, to use reasoned process to weigh the risks and benefits of the choices. And fourth, to communicate relatively consistent or stable choices. The capacity is not a uniform concept, but rather is directed at concrete decisions, tasks, or areas. The decisive factor is therefore the specific nature of the decision to be taken. So, as mentioned, the knowledge of the forms and elements of legal capacity is essential to comprehend a legal decision. Therefore, the basic elements are summarized as follows. First, the natural ability to grasp the benefits and of interfering with a legal system, with legal good. Second, ability to rationally assess and associate risk and to weigh the benefits and risks against each other. The consent to a medical treatment includes also a subjective value decision, a factual decision, and a conflict decision. So, some final words and thoughts. First, we have to be aware of the different concepts, the different types of legal capacity, and different elements in diverse contexts. For instance, the Australian Law Reform Commission explored the language used to describe people with disabilities, stating that certain words may have negative connotations, is also important. Words should not help lessen the dignity of a person. Many words are associated with established meanings or linguistic usage. The aim of the ALRC is to bring back human dignity and support to the legal language with the terms it uses. Changing a concept that is almost thousands of years old will take time, especially with regard to legal practice. In my opinion, the element of support in the term of supported decision-making must always be taken into consideration, especially when it comes to the assessment of natural skills and, as a result, legal capacity. In doing so, the required and adequate support within the scope of decision-making or assessment is broadly missing. A final thought, the principle known as use it or lose it refers to the situation in which a person retires from working life, and due to the cessation of the intellectual requirements of the work, the mental abilities, because they are no longer in the extent needed, begin to decrease. This does not apply to situations of people with mental and psychological disabilities. Conversely, for this group of people, the promotion of intellectual abilities, for example, through gainful employment, participation in legal supported relations, or social activities, is an essential key element. The mental abilities can be made possible and visible through increased involvement of a person. The necessary and appropriate education about concrete circumstances of a situation in the sense of the supported decision-making and the use of the necessary forms of communication, and thus help to realize participation in legal relations. Of course, there are some cases in practice where all forms of support and communication cannot enable a person to make an independent, self-determined decision. Nonetheless, I believe that significantly more effective people with the necessary and appropriate support will be in the position to make their own legal decisions. Thank you very much and have a good day. Goodbye.